for His Majesty's Revenue and Customs against the Professional Game Industry Official Limited.
My Lord, good morning. I'm here in this matter with my friends Mrs. Hicks and Mr. Sheehan for the appellant, who I will refer to as PGMOL. My friends Mr. Norbat and Mr. Payne appear for the respondent commissioners. It's convenient to the court. I propose to address my lords, my lady, under 6 headings. First, some observations by way of introduction. Secondly, the test for employment status in outline. Third, the nature and scope of the concept of mutuality of obligation. Fourth, the decisions below on mutuality. Fifth, the issue of control. And then lastly, sixth, the disposal of this appeal. Observations by way of introduction. As the court will have seen, PGMOL is a not-for-profit body set up by the Football Association, the FA Premier League and the English Football League, or EFL, to provide referees and refereeing services to the professional game of football in England and Wales. There are some referees, the select group, who are employed by PGMOL on a full-time basis. They typically referee in the Premier League and the Championship, or in old terms, Division 2. There is another group, the national group, who have been treated by PGMOL as self-employed. They're now also workers, and they typically referee in League 1 and League 2, in old terms, Divisions 3 and 4. We're concerned with the tax years 2014-15 and 2015-16. That encompasses the football seasons 2013-14, 14-15 and 15-16. These national group referees have other jobs and referee in their spare time as a hobby. They were paid around £350 per match as a match fee to referee. The games they referee are professional. They are no doubt important to the teams and players concerned, but this is not necessarily glamorous. It may have been a wet Friday evening in December to see Tranmere Rovers play Cambridge United. First-tier tribunal heard evidence about their dedication, the fanaticism even, of these referees to be a good referee, to referee well, and found them to be ambitious perfectionists. That's the first tier at paragraph 104. It is, however, to reiterate, a hobby which must take second place to their work commitments. They are not, the first tier found, refereeing for the money. It's the first tier at paragraph 104. As referees, they are on a register maintained by the Football Association, which is their regulator. PGMOL can cease to use them as referees, but only the Football Association can stop them refereeing. In FA terms, these national group and indeed the select group referees are at the top of the pyramid. They are in FA terms level 1 referees. There are 8 levels below that, down to Sunday morning football at level 9. PGMOL provides referees and refereeing services in the professional game using level 1 referees. PGMOL also has some involvement in training and development of level 2 referees to ensure an adequate pipeline of people who might become level 1 referees. But it is the FA that runs the refereeing pyramid from level 2 down to level 9. Now, this appeal is directly only concerned with level 1 national group referees, but the relevant principles, and in particular HMRC's case, apply further down the pyramid to other referees who simply agree to referee a game and receive a match fee from the FA. Similarly, whilst no assessments have been raised to our knowledge, the same issue arises in relation to the football leagues and competitions in Wales, Scotland and Northern Ireland. The court will also have identified that there are two relevant contracts here governing the position of the national group referees. There is a season-long overarching or umbrella contract and a match-specific engagement offered and accepted through what is called the Match Official Administration System, or MOAS. The referees signed the umbrella agreement for the whole football season. The match engagement specific contract would typically be offered and accepted on the Monday before a Saturday match, and that contract would come to an end with the submission of the referee's report after the match, either on the Saturday evening or perhaps early Sunday morning. So the match-specific engagement is in effect typically a 6-day contract to referee in a particular match. It's now common ground that the umbrella contract is not a contract of employment, since inter alia it lacks sufficient mutuality of obligation. The debate before this court is about the status of the match-specific engagements. The First-Tier Tribunal heard evidence from Mr. Riley, then responsible for running PGMOL, and an ex-referee himself, and from 8 referees, some of them national group referees, some of them from lower down the refereeing pyramid. And as we shall see, the FTT identified the relevant legal principles, made extensive findings of fact, evaluated those findings of fact, and considered the application of the relevant legal principles to those facts. The FTT concluded that the match-specific engagements gave rise to a contract, but that there was not sufficient mutuality or indeed control to justify a conclusion that that contract was a contract of employment. The upper tribunal agreed as regards mutuality of obligation, but thought that the first tier had erred as regards control, but it did not need to remit the matter to the first tier, given its conclusion as to mutuality of obligation. The Court of Appeal, in contrast, thought that there was an error of law as regards mutuality of obligation and as regards control, and that the case should be remitted to the first tier to discern whether there was sufficient mutuality and indeed sufficient control. We understand it to be common ground that the findings of fact are for the fact-finding tribunal, here the FTT, unless they arrive at a perverse finding of fact. That is not said here. Equally, evaluation and weighing of those facts is also a matter for the first-tier tribunal, again, unless that exercise is perverse, and we understand this is, again, not said to be the case here. The determination of the relevant legal principles is obviously a question of law, which this court could, or can, and here will have to address. And just for your note, that is a potted summary of the relevant position as regards matters of fact and law, drawn from my Lord Legate's judgment in the Uber case, in particular at paragraph 118. That's bundle page 789.
789. 89. Thank you.
So the debate between the parties is now really twofold in this court. First is a debate as to the relevant legal principles as to the nature and scope of mutuality of obligation. And secondly, as regards control, the debate is not as to the relevant principles, they appear to us to be common ground, but whether indeed the first-tier tribunal here in fact erred in its application of those principles. And of course, ultimately, the question for this court is whether the first-tier tribunal erred in law. If it did not, there was no basis for either the upper tribunal or the Court of Appeal to interfere. So that is the ambit of the debate before this court. That then takes me to my second heading, the test for employment status in outline. This appeal, as the court will be well aware, is a tax case about the status of the national group referees for income tax and national insurance contribution purposes. The relevant legislation asks in each case whether the referee is an employee engaged under a contract of service. Legislation is in the authorities bundle at pages 250, 252 and 258. And again, as my Lord will no doubt be well aware, tax has relevantly two categories of person operating in the world of work. There are employees and there are those who are self-employed, sometimes referred to as independent contractors. Sometimes it's economically advantageous to be an employee, sometimes it's economically advantageous to be self-employed. The tax treatment simply follows the classification that is given by other principles. But it's also highly relevant when considering various legislative codes which confer differing degrees of protection on categories of person operating in the world of work. And in terms of employment protection, there are now three relevant categories: employees, workers, and the self-employed. Just for your note, workers are in tax terms a type of self-employed person. And that was Lady Hale in the Bates van Winkelhoff case, approved in this court in Uber, in my Lord Legate's paragraph 38, which is page 769 of the bundle. So for tax purposes, two categories. For employment protection purposes, there are three categories. Given, however, that employment status is relevant to both tax and employment rights, the test of what it is to be an employee under a contract of service should, we say as a matter of principle, be the same whether one is looking at a tax question or an employment protection question. And that was the conclusion that my Lord Richards arrived at in the Athol House case in the Court of Appeal. My Lord's paragraphs 56 and 60, bundle page 828. So we say as a matter of principle, and at least at Court of Appeal level, as a matter of authority, the test ought to be the same, because one is ultimately concerned with whether there is a person who is an employee under a contract of employment, whether that's a tax question or an employment protection question.
Is that common ground? Yes.
We believe it to be common ground, yes.
Well, it certainly historically has been common ground for many years, yes. But HMRC has looked to the common law in order to answer the question.
Yes. Now, one other observation by way of principle, if you like, we say, as a matter of principle, that there should be a single test to determine employment status. There is nothing to be gained by a multitude of tests, the application of one or more of which might produce different answers. So the law should have one test to determine whether someone is an employee under a contract of employment. That again is a point made by my Lord Richards in the Athol House case at paragraphs 61, 71 and 122.
The page number? No, don't worry. It must be about 828.
Yes.
I'm sorry, my Lord.
61 starts on 829.
829.
And the following.
'71 is page 830, and then 122, my Lord's judgment, is at page 843. But we do say, before descending to the detail of the relevant test, it is worth noting that at a reasonably high level of generality, the aim of the exercise in our submission is to identify a particular relationship of some substance which is worthy of the characterization of an employment relationship, on the one hand, to be contrasted with a more transactional arrangement between the provider of a labour service and the payer of a fee for that service, where the provider of the service might just be a worker or might just be self-employed. Boiling that down a little further, it is a truism, but all contracts in the world of work involve the provision of a labour service for a fee. Not all such contracts are contracts of employment. Now, drawing that distinction on the authorities requires focus on mutuality of obligation and on control, and then on all other relevant factors in order to classify that contractual relationship in the round. Now, it is fair to say, if one sits down and reads the authorities in chronological order, they are not always easy to reconcile. We do now have the benefit of my Lord Richard's recent summary in Athol House, the detail of which I'll come back to in a little while, but for our part at least, we see the exercise in this court as an exercise in searching for principle rather than attempting to argue by analogy from the facts of one case to another. And equally, the test that is arrived at by this court needs obviously to be flexible, sufficiently flexible to deal with the many different ways in which labour services are now provided in this country, and also to provide sufficient latitude within a framework for the fact-finding tribunals made up of lay people and lawyers to address particular fact patterns. The legal test provided by the common law cannot be seen as or applied as if it were some rigid box-ticking exercise akin to a statutory code.
Yes, but Mr. Justice McKenna wasn't writing a statute.
He wasn't.
And he was also writing what he did in the context of the world of work in the 1960s.
Yes, Mr. Latimer in that case, as I'll show your lordships in a little while, first signed his contract in 1959, and he signed another contract in 1962, and the world of work, I suspect even for the delivery of concrete, is different now than it was in those years. It's a point I'll come back to, but on the authorities, the test for employment status does look to, rest on maybe a little strong, but look to the judgment of Mr. Justice McKenna in 1967, where he identified that in order to be a contract of employment, three aspects must be considered. Firstly, whether there is sufficient mutuality of obligation in relation to the particular contract. Secondly, whether there is a sufficient right of control. pausing there, each of those elements is seen on the authorities as a precondition in the sense that if either is missing, there is no contract of employment, but if both are present, the contract is not necessarily a contract of employment. And then the third element is whether the contract as a whole, looking at all of the relevant factors, including the nature and degree of mutuality of obligation and control, leads to the conclusion that the particular contract and the particular relationship embodied by that contract is a contract of employment. And because His Lordship in Ready Mix expresses that third element in at least one place as a negative condition, there was some debate on the authorities as to whether one should approach that third stage with some kind of presumption that the contract was a contract of employment, or a predisposition to find that it was. Not so, said my Lord Richards in Athol House, paragraphs 75 and 113, bundle pages 831 and 841. Point I will come back to, but one doesn't approach that third element with a presumption just because the first two elements are present. One last point by way of outline. The status of being a worker is provided by statute. And that worker status test is different to the test of whether someone is an employee at common law. And as we shall see, one of the key differences is that the common law test seeks to identify particular obligations on the putative employer and on the putative employee. But the worker statutory test only looks to the obligations of the putative worker. So when we come to look, as we will have to, at cases on the worker test, one needs to read those cases with that distinction in mind. And in particular, one needs to be wary of an analysis of worker cases which may not be equally applicable in a common law employment question. And the last point by way of overview, to reiterate a point I made a moment ago, that one needs to be wary of thinking of the common law employment test in terms of rigid limbs. There is a danger in reading what Mr. Justice McKenna said in Ready Mix as requiring separate limbs, or reading one limb as a gateway to another. That's not what he intended. But there is a danger in pursuing that line of thought because it detracts from the obligation ultimately to reflect the nature and extent of both mutuality and control, and also to look at all relevant factors in the round. Now that's what I say by way of overview of the employment status in outline. That takes me to my third heading, which is the bulk of my submissions, which is the nature and scope of the concept of mutuality of obligation. Now, our starting point here, accepting and endorsing the analysis of my Lord Richards in Athol House, is that there is a single test for employment status, founded on an analysis inter alia of mutuality and control, and insofar as there are authorities that suggest a different approach of asking whether a person is in business on his or her own account, or of applying a simple multifactorial assessment, those authorities are not ultimately seeking to say anything different. They are different ways of analysing the nature and extent either of mutuality or of control, or of weighing up all relevant factors at the third stage. So our jumping off point, if one likes to put it that way, is Lord Richards in Athol House. There is one test. So what then is meant by the concept of mutuality? It would be useful, if the court will entertain me briefly, actually to look at ready-mix concrete. It's a case that is often cited and I wonder now rarely read. If we could turn it up very briefly, beginning at bundle page 266. And feature I invite the court to note very briefly. In some of the authorities, there's a debate about whether there's a contract at all. Well, that wasn't relevant in the case of Mr. Latimer because he'd signed a contract. So pages 269 and 270 record the contracts that he signed, one in 1959 and then a replacement contract in 1963. There was some element of a right to substitute. The court will be well aware there is a debate in some of the authorities as to whether the obligation to do the work personally is present if you have the ability to substitute another. And in this particular case, he had some ability for someone else to step in and do the work on his behalf. And that's reflected at pages 279 and 280. But the relevant facts that were found are suitably summarised in the findings of fact made by the relevant minister, so the national insurance case, at page 282 of the bundle, 513 letter D onwards. That records the minister has found a number of facts which he has stated in the case. And they're then listed from letter A all the way down to letter N on page 283. Some of which are disregarded, foot of page 283. And the famous passage, page 515 of the report, 284 of the bundle, is at letter C, where his lordship says there are 3 conditions to be fulfilled. The servant agrees that in consideration of a wage or other remuneration he will provide his own work and skill in the performance of some service for his master. Roman 2, he agrees expressly or impliedly in the performance of that service he will be subject to the other's control in a sufficient degree to make that other master. And then 3, the other provisions of the contract are consistent with its being a contract of service. He has a little more to say about Roman 1 and 2. For our purposes, for the moment, we're only interested in 1. As to 1, letter E, there must be a wage or other remuneration, otherwise there will be no consideration, and without consideration, no contract of any kind. So he rightly identifies that you need payment to amount to consideration for there to be a contract. And note also that he is expressing the type of obligation that you need to find in order to justify a conclusion that there's a contract of employment in terms of the obligation on the putative employee. He doesn't say anything here about the nature of the obligation on the putative employer. So Roman 1 between letter C and D is expressed in terms of the putative employee. Relevantly as regards mutuality, there's one other passage that it would be useful for me to show the court. Page 293 of the bundle, page 524 of the report. His Lordship harks back to an earlier case, Park and Wilson's and Clyde Cole, repeated by Lord Thankerton in Short and Henderson, the 4 indicia of a contract of service. So it's page 293 between letters C and D. So A is the master's power of selection, B is the payment of wages or other remuneration, C is the right to control, and D is the right of suspension or dismissal. And Mr. Justice McKenna goes on, it seems to me that A and D are chiefly relevant in determining whether there is a contract of any kind between the supposed master and servant, and that they are of little use in determining whether the contract is one of service. The same is true of B. Just pausing there, the payment of wages or other remuneration is of little use in deciding whether it's a contract of service, then reading on, unless one distinguishes between different methods of payment, payment by results tending to prove independence, and payment by time, the relation of master and servant. So even then, His Lordship was recognising that paying for a labour service doesn't necessarily tell you anything about the nature of the obligations on either side of that agreement. And to reiterate a point I made a second ago, there's no discussion in Ready Mix of the nature and type of the obligations that one might find on a putative employer. Pausing there just to stand back for a moment, the nature of mutuality can be used to determine if there is a contract at all. I quite accept that. And that sort of debate is commonly seen in agency or tripartite cases where Mr. X wants to claim to be an employee either of the agency or of the end client, but in either case needs to justify the existence of a contract. It also arises where, for employment protection purposes, Mr. X needs to establish that there is some period of continuous employment. So you might need 2 years of continuous employment in order to justify a claim for unfair dismissal. And in such cases, it's not uncommon to find the courts and the tribunals saying that there are no mutual obligations and thus no contract at all. And a good example of this is the House of Lords decision in Carmichael, where the court concluded, on the basis of findings made by the Industrial Tribunal, that there was simply no contract at all when Mrs. Carmichael and her colleague were not working. Just for your note, that's Lord Irvine at page 438 of the bundle, page 2047G, and Lord Hoffman at page 442 of the bundle, page 2051D. So the notion of mutuality of obligation can be helpful in such a case in answering the logically prior question of whether there's a contract at all. It is also...
It's terribly helpful to regard it as one notion.
Oh.
It has various... part of the problem with the concept of mutuality of obligation is that it's used in various different senses, which is quite important to unpick.
My Lord, yes. The point I...
For example, the question whether there is a contract is a different sort of question from the question of the nature of the contract.
My Lord, yes. And there are passages in the authorities, in particular in the judgments of Lord Justice Elias as he became, suggesting that the only rule of mutuality in the employment context is to determine whether there's a contract at all, or whether it's a contract somewhere in the world of work with control and the ready-mix concrete third element being the only elements of the legal test which would divide a contract of employment from some other kind of contract. I anticipate my Lord has this in mind, but one can see that in what Mr. Justice Elias, as he then was, said in the EAT, in a case called Stevenson and Delphi Diesel. I'll give you the references. It's paragraphs 11 to 16 at bundle page 475. He says the same thing in the EAT in a case called James and London Borough of Greenwich.
Sorry, was that 465, did you say?
475, my lady. And then James and London Borough of Greenwich, he says the same thing at paragraphs 16 to 17. That's page 540 of the bundle. And then he comes back to this in the Court of Appeal in a case called Quashie and Stringfellow. And this one we perhaps ought to look at. It's at page 616 of the bundle.
Good example of a case where there was a contract but not of a relevant kind.
Well, it was a contract with the wrong person, if one likes. The dancer in Quashie had an obligation to pay the club for the right to dance, but her income was paid by those who attended the club.
Yes, so there was a contract between her and the club, but it wasn't...
Which involved mutuality of obligation.
Yes, in one sense.
But the payment was in the wrong direction.
But the payment was going to Mr.
It
Strickland.
wasn't being paid by the club for personal services.
Yes. Well,
There was a later case about the VAT treatment of dancers.
there was, my lady, a case called Spearmint Rhino, which looked at that same tripartite relationship between those who attend the club, the dancers in the club, and the club itself. But in the Quashie case, I just want to show you one passage because Lord Justice Elias, as he then was, realises that he perhaps put it a little dogmatically in some of the earlier cases. It says paragraphs 13 and 14 at pages 616, 617. Paragraph 13 records what he'd said in Stevenson and Delphi Diesel, and you can get the sense of it in the first line of his indented paragraph 11. The significance of mutuality is that it determines whether there's a contract in existence at all.
What he backed off from was the last sentence of 14.
Yes.
Saying, well, I've ticked the mutuality box. It's now all about control.
So he rows back. For our part, he doesn't row back quite far enough. But he was there rowing back from what he'd said earlier. For what it's worth, what he'd said in James and London Borough of Greenwich was to like effect, but that was not the approach that the Court of Appeal adopted on appeal. So again, just for your note, on appeal, it was Lord Justice Mummery in the Court of Appeal in James and London Borough of Greenwich. Paragraph 45 at page 562, His Lordship there adopted a much more traditional concept of mutuality of obligation as being about the nature of the mutual obligations that would cast light on whether it's a contract of employment rather than merely the existence of the contract. And for what it's worth, we would accept and endorse the approach of my Lord Richards in Athol House, where again, my Lord does not regard mutuality as simply governing the existence of a contract or a contract somewhere in the world of work.
Well, then you'll need to explain what it means in the later context.
Yes.
And whether it means the same as you've been talking about. Obviously, it doesn't.
Well, I'm going to address just that. Now, it is clear from ready-mix concrete, and so far as we can see, not questioned in later authorities, that the obligation on the putative employee, as regards mutuality of obligation, is to do some work personally. It's an obligation of personal service. So what then about the obligations on the putative employer? they were not addressed in ready-mixed concrete itself, because there the judge focused only on the payment of a wage or other remuneration.
Well, that obviously is an obligation on the employer.
Yes. But merely paying for a labour service, in our submission, may be a necessary element, but it's not a sufficient element. Now, the next waypoint in the development of the authorities here is a decision of the Court of Appeal in a case called Nethermere, where Lord Justice Stevenson reviews some of the older authorities to explore the nature of the obligations on the putative employer. And Nethermere, the report begins at page 358 of the bundle. The passage I'd like the court to turn up begins at page 368 of the bundle, letter G. Here's a paragraph beginning, does the law require any and what mutual obligations before there can be a contract of service? And then over the page at 369, between letters A and C, he makes two relevant points. He's here concerned with the obligation required of an employer. He was referred to old cases, and then picking it up 4 lines down. For that purpose, the court had to decide that there was mutuality of obligation, an obligation on the master to provide work as well as wages, complementing an obligation on the servant to perform that work.
So where are you reading from? I'm so sorry.
Between letters A and B on page 369.
Thank you.
4 lines down, the sentence begins, for that purpose.
When he says for that purpose, what's the court had to decide? I mean, is he referring to something specific about the relevant legislation?
No, he's referring generally to the obligation required of an employer.
I see. Thank you.
Because what he does, in the preceding paragraph at the foot of the previous page, he's asking, well, what are the mutual obligations you need?
Yes.
And then the top of the next page, he first addresses employer's obligations, and then the next paragraph beginning below letter C is the obligations of the employee.
I think the words for that purpose must mean for the purpose of deciding whether there was a breach of contract under the statute. He's explaining the context in which the court had to decide that there was mutuality of obligation in that sentence.
Yes. But, my lord, in that statute, the legal consequences followed if you were the servant of a master.
But then the following sentence, letter B, is important.
Yes. So he goes on to say, later cases have shown a normal rule is that a contract of employment does not oblige the master to provide the servant with work in addition to wages.
Well, I mean, this obligation to provide work, are they actually, what they're actually talking about is the obligation to provide the opportunity to acquire wages or to earn wages. And if you're going to pay the person, whether they do the work or not, then there can't be, or are you talking about an obligation actually to provide them with something to do? Or is it just an obligation to provide work because it's assumed that that is the only way in which they will earn wages?
Well, ultimately, my lady, it's the latter.
Yeah.
Because I use worker in a non-statutory sense. The worker has an economic interest in the money, which is the product of being offered the work.
Yes.
But what Lord Justice Stevenson is saying is more modern authorities dating from the 1940s onwards focus on the obligation to provide work, but not work and wages. Now, I'll come in a second to what that might mean, but just two other things to note on that page 369. Between letters C and D, he addresses what is the obligation required of an employee. So an obligation to serve. He then quotes from Ready Mixed Concrete between letters D and E. And then again at letter F. And then between letters F and G, he uses a phrase that's picked up in the authorities. For our part, we think this is the first time it appears, the irreducible minimum of obligation on each side. And he says, I doubt if it can be reduced any lower than the sentences I have just quoted. Now, it's not immediately clear which sentences he means, but by inference, it's the citation from Ready Mixed Concrete. But he is there putting the putative employer's obligation in terms of an obligation to offer work or provide work. Lord Justice Kerr
Sorry, in letter F to G, there must, in my judgment, be an irreducible minimum of obligation on each side, and it can't be reduced any lower than the sentences I have just quoted. Now, what he quotes is the three conditions by Mr. Justice McKenna, and then the wage, and on the other hand, the workers doing the work. He isn't saying anything about the obligation on the employer to provide work, is he?
My Lord, that is one of the difficulties with this judgment, because in later authorities you see this reference to the irreducible minimum of obligation picked up. But what he describes apparently as that irreducible minimum, citing from Ready Mix, doesn't actually address the obligations on the employer.
Well, it does.
To provide the wage.
He's got to pay a wage. He's got to agree to pay a wage. And that's the thrust of his discussion all the way down that page. You don't have to be obliged to provide work. It's enough that you're obliged to pay for it.
Well, my Lord, that's not, with respect to how we read the first substantive paragraph on that page. He's saying the old cases establish an obligation to provide work as well as wages. And then at letter B, later cases have shown that the normal rule is that a contract of employment does not oblige the master to provide the servant with work in addition to wages.
Yeah, in other words, you've got to agree to pay wages. You don't have to agree to provide work.
It's just your last comment. I thought you were suggesting that this was authority, or had been treated as authority for the obligation to provide work. And it seemed to me to be saying the opposite.
Well, the way we read that main paragraph between letters A and C is he identifies the very old cases as saying obligation to provide work and wages. And then he's saying you don't have to provide work in addition to wages.
Yes.
Yes, so you don't have to provide work.
Or you don't have
to provide wages.
So his irreducible minimum, when you get to letter F to G, doesn't require the provision of work.
And doesn't require the the putative employee to work. If not offered work, the putative employee obviously can't work, but he must be paid wages. Is that what you're saying?
Paid wages where work is not offered.
Correct. Yes, that's as I understand your submission.
But
What you say
I was
comes
trying
out
to
of this
get
page.
That was why I asked the question, is there an obligation to provide work so that the putative employee can earn the wages, to which I thought you'd said no. Of course, if he offers the putative employee work and the employee does the work, then he's got to pay him for the work. I don't think anyone could doubt that. But the question is, does he have to provide the putative employee with the opportunity to earn those wages, or can he just say, I don't need you and I'm not going to pay you anything?
Well, can I answer that, Mary, when we look at the later authorities? Because that does.
But what are you what we're puzzling is what you're saying this step is on this page. What is being said there?
We read, and maybe there's nothing between our submissions and what the court is putting to me, that Lord Justice Stevenson is identifying that there was thought to be an obligation to provide work as well as wages. He then says the 1940s authorities show that the putative employer is not obliged to provide the servant with work in addition to wages. He then cites from Mr. Justice McKenna and Ready Mix, where the focus is only on the payment of a wage. He then describes that as an irreducible minimum of obligation. What I was about to show you was Lord Justice Kerr and Lord Justice Dillon say something slightly different.
Yeah, but just analysing as a matter of contract law, if you enter into an employment contract, I employ you to do certain work, I'll pay you X, and then you don't provide the work, you still have an obligation to pay X, subject to mitigation. You can go off and mitigate your loss. But I mean, why is there any obligation on the employer to provide the work in order to determine there has been an employment contract?
Because, my Lord, one has to eventually draw a distinction between a relationship that we ascribe the label of contract of employment to, having weighed up all of the relevant factors, and the simple case where I might engage a decorator to paint my kitchen. Now, let's assume, for the sake of debate, that I am so picky about that process that I have control over him. If the agreement between us is that I will engage him to paint my kitchen, and he turns up and does the work, such that I have an obligation to pay him the £500 that I agreed at the outset, if that is sufficient alone to satisfy the irreducible minimum of mutuality of obligation, the fact of payment for work done then either the heavy lifting for the discrimination between contracts of employment and contracts of service has to be done by the control test, or it has to be done at the third weighing of all of the relevant factors test. Now, what Lord Justice Stevenson is grappling with is what obligations are there on a putative employer. Here he's addressing it as a matter of authority rather than as a matter of principle. But one ultimately has to have in mind that if one is to draw this distinction, perhaps I put it as a question, is the distinction to be drawn on the basis that payment for work done pursuant to a contract to pay for work done, is that itself sufficient to satisfy the concept of mutuality of obligation?
And as I understand it, HMRC say, yes, it is.
They do.
As a matter of interest, the cases at the top of the page that referred to an obligation to provide work was not implied by this court in the salesman's contract. Was the salesman's contract one of employment or not? Because that may be quite relevant to the point we're discussing.
I confess, Lord, without checking, I can't answer that. But the Devenold case was a piece worker's contract. So
does that count as an employment contract?
there was said in Devenold to be an implied obligation to provide piecework to be done, so as to make it an employment contract in Devenold. To point my Lord Richard's addresses in Athol House, which I'll show the court in a little while.
Yes.
And perhaps over the shorter journal, we can check Turner and Sword, and I'm afraid I just don't remember.
The reason I picked up was you were about to move on from this passage, but I may have misunderstood you as saying that this was authority for the obligation to provide work, and it seemed to be saying the opposite. But I don't think we can get much more out of this page, so perhaps we should see what the other judges said about this case.
Can we do that, and then I'll show you some later authorities that perhaps makes this a little clearer. So, Lord Justice Kerr...
He's actually Lord Justice Carr.
I'm sorry. Lord Justice Carr, page 375.
The more recent judge of the same.
Yes. Page 375 of the bundle. Between letters E and F, His Lordship says this: for this purpose, it is unnecessary to decide whether the alleged employer's obligation is to provide a reasonable amount of work, as Mr. Tabachnik contended, or whether it is merely to pay an agreed and reasonable sum for whatever work is done. So His Lordship there is recognising the question, but not answering it. And then Lord Justice Dillon, page 378 of the bundle, between letters F and G, it is said nonetheless that there is one sine qua non which can firmly be identified as an essential of the existence of a contract of service, that is that there must be mutual obligations on the employer to provide work for the employee and on the employee to perform work for the employer. If such mutuality is not present, then either there is no contract at all, or whatever contract there is must be a contract for services or something else. And that formulation is in effect accepted by His Lordship at page 380 of the bundle, page 634 of the report, at letter G. So he expresses that in terms of the putative employer's obligation to provide work. There is a helpful review of how the authorities have developed here in a case called Cotswold Developments, decision of Mr. Justice Langstaff sitting in the EAT. Begins at page 515 of the bundle. This was a claim by Mr. Williams for unfair dismissal. He worked for a company called Cotswold Developments Construction, which in turn was engaged by London Underground to do various building works. He brought the claim for unfair dismissal against the subcontractor. There was a debate as to whether he was a worker for statutory purposes or an employee. the Employment Tribunal said that he was a worker but not an employee, and the EAT concluded that the Employment Tribunal had erred as regards both conclusions, and then remitted the case back to the Employment Tribunal. But His Lordship sets out from paragraphs 16 through to 24, so pages 518 to 519, how this notion of mutuality has developed through the authorities, and in particular, what is the sort of obligation that you would expect to find on a putative employer. I don't invite the court at this stage to read all of those paragraphs, but there is there a useful summary.
Does he come to a conclusion? The best way of seeing that, my lord, is there's a passage begins at page 521 of the report, headed at paragraph 40, discussion. And then his conclusion is at paragraph 47 onwards. Making the point that there needs to be a contract at all. And then at the end of 47, making the point that one needs to address the nature of the mutual obligations. Sorry, where is it? Forgive me.
Paragraph 47, my lord, page 521, right-hand column.
Yes. These met, I see.
So the question 1, is there a contract? Question 2, what type of contract?
I see.
Yes.
Yes.
What does he say anything about what the test is for determining what type of contract?
Yes, if one reads on, my lord, he cites some of the arguments for the various parties, but picking it up at paragraph 54, page 522, he recognises the different senses in which mutuality is used. He makes the point about 8 lines down in that paragraph that regard must be had to the nature of the obligations.
Oh, yes.
And then he encapsulates it at paragraph 55, in particular the left-hand column on page 523, 7 or 8 lines down. The focus must be upon whether or not there is some obligation upon an individual to work and some obligation upon the other party to provide or pay for it.
Sorry, paragraph?
55, my lord, but the left-hand column on page 523.
So he seems to be suggesting that if you have to pay, whether you provide the work or not, then that would be a sufficient obligation on the putative employer.
Yes, and the way it's put, there's one other authority I would like to show the court, but the way it's put is that the obligation on the putative employer is to provide work or to pay in lieu of the provision of work.
If you have to pay in lieu of work, that, as a matter of common sense, is a fairly clear indicator that it is a contract of employment, because one doesn't tend to engage decorators and pay them whether they actually do any painting or not.
Yes, the lady.
I don't think that's a fair description of his analysis, because he seems to be rejecting the suggestion that the employer must have an obligation to provide work, and saying that it's sufficient that the employee must have an obligation, and enough of the employer to agree to pay for it.
Well, it's the sentence about 7 lines down in the left-hand column on page 523, so it's paragraph 55. The focus must be upon whether or not there is some obligation upon an individual to work, and some obligation upon the other party to provide or pay for it.
But I think the point is provide or pay.
Yes.
Yes.
So not necessarily provide, paying for it is enough.
Paying
In lieu of
in lieu of it.
You, and that's the suggestion is that's a sort of essential element of a contract of employment rather than a contract for services.
Yes.
Well, I don't know. I think he's the obligation not to. It is not saying pay in lieu of work. It's enough that the employer agrees to pay for work that's done, which the individual has agreed to provide.
Well,
Anyway, I don't think we can get positive support for your contention out of this, because all the build-up to there is emphasising, as other cases do, the obligation on the employee.
Well, it may help to discern the emphasis that he places in that paragraph 55. If one looks back to his paragraphs 19 and 20, this is page 518. So he recognises that the irreducible minimum of obligation resting upon the employer has been variously stated in different cases. And then he cites, actually from the authority I was going to show the court, that paragraph 20, it's unnecessary, however, to approach the definition of the obligation which is required on the employer's side upon too narrow a basis. So Christopher Slade in Clark and Oxfordshire Health Authority. The mutual obligations required to found a global contract of employment need not necessarily and in every case consist of obligations to provide and perform the work. To take one obvious example, an obligation by the one party to accept and to do the work if offered, and an obligation of the other party to pay a retainer during such periods as work was not offered, would, in my opinion, be sufficient, or would be likely to suffice. So he is putting it in terms of an obligation to provide work or to pay in lieu. And if one stands back for a moment, my lord, if one is to use this as a meaningful discriminating factor from my simple case of engaging a decorator to paint my kitchen, where I will pay him if the work is done, one has to find some stronger obligation on the employer.
One does, if one's going to use this for that purpose.
Yes.
As opposed to simply delineating that we're in a field where we then need to go on to decide whether it's a contract of employment or one of services.
Well, if I pursue my Lord's observation just a little, that would then require the emphasis to be on the control element of what Mr. Justice McKenna said in Ready Mix, and then on the weighing up exercise at the third stage.
Well, it's not only weighing up exercise, there are other indicia that may be relevant at the third stage.
Well, by weighing up, I had in mind weighing up all relevant.
Yes.
Can you just remind me where in in the page in the bundle where Mr. Justice McKenna's tripartite test is. I'm sorry, I just haven't got it.
Yes, it's 269.
I think it's at
No.
284C.
Yes,
Yes, thank you very much.
grateful. 284C.
I mean, is it your submission, or will you be making a submission that an obligation to provide work is a necessary requirement of the contract of employment?
Yes, the way it's portrayed in the authorities is that that is a precondition, the presence of which allows a conclusion that there is a contract of employment depending on other matters, but the absence of which would bar that conclusion. And that's the way my Lord Richards puts it in Athol House.
But you would accept that payment in lieu of work would be all right?
Yes.
Yes, what we were looking at in the Cotswold Developments case was, I think, a discussion of an overarching contract, and it would be a contract of employment if the employer provided work or paid in lieu of work, presumably throughout the period.
Well, in Mr. Williams's case, he had no written contract. So one gets that from page 515, left-hand column, just above, just under the heading "The Facts." So he had no written contract, and as further down that left-hand column, he worked regularly for Cotswold. This is 15, 20 lines down, throughout the 21 months of his engagement. There was no suggestion he'd worked for anyone else during that period.
Yes.
So that was if one wants to categorise contracts, as we may have to in a moment, that was a single contract case.
Yes.
There wasn't the complicating factor of an umbrella contract and then individual engagements.
The reason I just wanted to look at page 284 again is that whatever the import of the first limb, Mr. Justice McKenna is seeing it as an essential element of a contract of service. If it's looked at as simply determining whether there's a contract at all, that seems to be a prior question. I mean, he's viewing it, for what that's worth, as an essential element of not just a contract, but a contract of service.
Well, Lord, yes, in our submission he does.
Yes, but that then begs the question of whether he's saying that any part of what he's saying is that there's an obligation to provide work on the employer, and there's nothing he says which does indicate that.
Well, look, I, for my part, and I think this will be common ground, he doesn't address in that judgment the nature of the obligations that you might find on the part of a putative employer. But he undoubtedly regards that part of his analysis as being a precondition to a contract of employment. Now,
I don't think there's any dispute that if the if the individual is not agreeing to work in return for pay, you're not going to get, there can't be a contract of employment. Well, the question is how much is built into that step, well, in the way of shutting out something that doesn't pass over it from being a contract of employment.
Yeah. If no labour service of any sort is ever provided for a fee, the dispute never arises.
When you talk about mutuality of obligation, as I understand it, you're saying there has to be an obligation on the putative employer to provide work, or if no work, then at least the opportunity, then some payment in lieu before there is a contract of employment. But when you say there has to be an obligation, does that have to be a contractually enforceable one? Because that would be quite a strict requirement if, in order to be contractually enforceable, you had to be able to say, well, how much work do you have to provide? How much pay do you have to provide? Because applying ordinary contract principles, if there wasn't that level of certainty, it would be difficult to say that it's actually a term of the contract. It's just too uncertain. But is that what we're talking about by a mutuality of obligation here?
The way it's put in the authorities, my lady, is that the obligation on the part of the putative employer is to provide some work, and the obligation on the part of the putative employee is to do some work. But the authorities do not go beyond that to identify what is meant by some, or how much is some.
But what do you say?
Well, for reasons I'm going to come to when we look at what the first tier analyse here, they found that there was some mutuality, but because of the terms of the arrangement between the referee and PGMOL, they found that it was not sufficient. And I'm going to say in due course that they made no error of legal principle in arriving at that conclusion, nor can it now be said that they made any error that would suggest a perverse conclusion in their evaluation of the facts. Because in our particular instance, the overarching agreement is not a contract of employment, that's now common ground. Referees were put in a position where they may be asked to do matches, and if they agreed, they would accept a particular offer, typically on a Monday. But then between that Monday and the Saturday, assuming it's a Saturday game, PGMOL may change its mind, or the referee may say, I cannot or will not do it. So ultimately, I'm going to say that that is not sufficient mutuality of control, mutuality of obligation, and the first tier's conclusion to that effect betrays no error of principle.
What about if when he's turned up at the ground, they say, oh, sorry, go home now? Or if once the match has started, he says, well, I've got something better to do this afternoon, so actually I'm leaving now. Surely you're not saying that there's no obligation at that stage.
The first tier found that once the referee turned up at the ground, then injury aside, PGMOL's offer of the game, which he had accepted, then was in effect a binding contract to referee the match. Now, injury aside, he could pull a muscle whilst warming up, but that aside. But for reasons we're going to see in a moment, the authorities say you have to find the relevant mutuality throughout the term of the contract.
Yeah, you say between Monday and Friday night that there wasn't that mutuality of obligation.
Or even between Monday and
Saturday afternoon.
Saturday lunchtime, yes. Because there were instances of people saying, well, I just can't get to the game.
The people stuck in traffic.
Yes. Or there was evidence before the first tier of a phone call at 1 o'clock before an evening game, somebody saying, well, my employer requires me to do something, I just can't make it.
Yes, if you're stuck in traffic and you can't do it, then that would be the same for an employee as it would for a contractor. But
the better example is somebody saying, well, my employer just won't give me the time to do it. But I'm getting ahead of myself just a little. Just one other reference in case it helps. The House of Lords in Carmichael, this is Lord Irvine, he expresses the obligation on the employer as in the language of an obligation to provide work. So that's page 438 of the bundle, page 2047, letter A of the report. he says, reading the contract, there's no obligation on the Central Electricity Generating Board to provide casual work, nor on Mrs. Lees and Mrs. Carmichael to undertake it. There would therefore be an absence of that irreducible minimum of mutual obligation necessary to create a contract of service, and he cites from Nethermere and Clark and Oxfordshire Health Authority. So in the House of Lords, at least, His Lordship put it in terms of an obligation to offer work. Thus far, I haven't stepped one step further on in my argument, which is to address the different sorts of contract. The Court no doubt has this in mind, but one may have to apply this test either to a single contract or only to a series of engagement-specific contracts, or in instances where there are both engagement-specific contracts and an overarching or umbrella contract. And those three categories of case are identified by Mr. Justice Briggs, as he then was in the Weight Watchers case. And that's at his paragraph 30, page 592 of the bundle. Now, we say, as a matter of principle, the relevant test for employment status should be the same whether one is seeking to characterize a single contract or an umbrella contract or specific engagement contracts. There should not be a different test, nor, so far as we can discern, is there any suggestion in the authorities that there should be a different test. I'm just pausing for a moment to contemplate that. If that were not true, you would then have a logically prior exercise in characterizing a contract into one of those categories, and you'd then have to apply some kind of different test according to that exercise. And that, with respect, is a recipe for chaos. So when one comes to the test for mutuality of obligation where one is concerned with a specific engagement contract, we say that test is and should be the same as it is when one is looking to characterize the nature of the obligations in a single contract.
When you say single, are you talking about overriding?
No, I'm just a single contract of employment. Now, to take my Lord's observation, we do say the same whether one is looking at an umbrella contract as well. If the relevant...
I mean, all these contracts are single contracts that are either of employment or not, so there isn't some third category, is there?
Well, the Lord ultimately, no. It's an analytical tool that may or may not be helpful. And of course, it's a slightly artificial divide because one may have what is badged as a specific engagement contract to do something over a very short period. It might just be to do a shift. So a bank nurse might be required to do a shift. Or it might be to work for a day, so a fruit picker might be engaged to work for a day. Or in a case we'll look at in a moment, Mr. McMeeton was asked to work for 4 days. Equally, your specific engagement contract might last a year. Weight Watchers we'll look at in a moment, it did. Or it might be 5 years. Mrs. Prater and Cornwall County Council had a specific engagement that was 5 years long. And the test for the status of those contracts has to be the same. One can't have a different test where it's a 4-hour shift compared to a 1-day contract or a 4-day contract or a 1-year contract.
But would you accept that the length of the period is a relevant factor in deciding whether it is a contract of employment?
Yes. Length and regularity are both relevant factors. But we say, as a matter of principle, and there is nothing to the contrary on the authorities, the test for mutuality should be the same. Now, in developing that submission, I want to make 5 points. First, the authorities are clear that the relevant inquiry is into the nature of the mutual obligations. And that can be seen in the judgment of Mr. Justice Buckley in a case called Montgomery and Johnson Underwood, paragraph 23, page 443 of the bundle, cited with approval by my Lord Richards in Athol House, at paragraph 100, page 838 of the bundle. And it is that search for the nature of the mutual obligations that is sometimes rightly described as a search for sufficient mutuality.
I have a great problem at the moment seeing how it's a matter of degree on any view, but
Well, my next submission, my Lord, begins that necessarily, and like the search for a sufficient right of control, is a question of degree.
I can certainly see control being a question of degree, but I have difficulty as well with mutuality.
Or whether one thinks of it in terms of degree.
well, what is the degree? I mean, what is the thing that has a scale that you may have more or less of?
Well, it's a requirement on the initially on the fact-finding tribunal to look at the length of the agreement, regularity of the agreement, the
How does the length of the agreement affect mutuality?
Sorry,
I thought I may have been confused, but I thought you said earlier that it had to be the same test regardless of the length.
well, my Lord, yes, but if one is going to form a view about the nature of, ultimately one is categorising the relationship, and one has to draw a distinction between a relationship of some sufficient substance to be worthy of the label contract of employment, on the one hand, in contrast to that which is merely the transactional provision of a labour service for a fee. Now, I recognise in stating that one is begging a whole series of questions about how you draw that distinction. But the broad divide in my submission is clear. And if we are told by the authorities to look to the nature of the mutual obligations, then one is required in our submission to identify the degree to which the employer, putative employer, is required to do something, or the degree to which the putative employee is required to do something. Now, whether that's expressed in terms of degree or sufficiency, I hold no strong view. But it is also necessarily an exercise in fact-finding and then evaluation of those facts for the tribunal of first instance. My second point is this, that the authorities establish that the requisite degree of mutuality has to be present for the whole period of the contract being tested. And that was said by my Lord, Mr. Justice Briggs, as he then was in Weight Watchers. And it will be useful to turn that authority up. It begins at page 583 of the bundle. Decision of the upper tribunal. This was about the employment status of what were called leaders who agreed to lead particular meetings of those who'd signed up to the Weight Watchers programme. And the debate was whether they were employees for tax purposes or not. And the first-tier tribunal had found that there was an umbrella contract and there were also meeting-specific contracts. But those meeting-specific contracts were to take a particular meeting. So you might take a Monday morning 11 o'clock meeting in a particular village hall, and you were typically expected to take that meeting for a year. So you had a series of specific engagements, because some of these leaders just did one meeting a week, some of them did 10 or 12 a week, but each of those obligations was a separate engagement. And the first-tier tribunal found that there was mutuality in the meeting-specific agreements, and His Lordship ultimately agreed.
Sorry, I think I got the wrong page.
I was at page 583, my lord.
I got 583. Thank you, 583.
Now, the ambit of the debate that we're relevantly concerned with in that case was my argument that because there was some freedom on the part of a leader not to do a given meeting, that was something that was inconsistent with a finding of mutuality of obligation. And what His Lordship goes on to say is, well, even though they had some freedom not to do a particular Monday morning, they were still bound by the obligation to do all of the other Monday mornings in that meeting-specific engagement. And so my appeal was rejected.
So when you say meeting specific, was that then per one contract for each Monday morning, or a contract for Monday mornings generally, separate from contract to do lots of meetings?
It was a contract in effect to do Monday morning in a particular place.
Every Monday morning?
Every Monday. And they typically lasted a year. So if I was a leader, I'd have an obligation to go to Wimbledon Village Hall Monday at 11 o'clock to lead that meeting. And then I might have another contract to go to a village hall in Putney on a Tuesday afternoon to do that meeting. They were separate. And my case was, well, as a leader, you have some ability not to attend a particular Monday. And His Lordship said, no, that's not good enough because you've got an obligation to do the other Mondays. I didn't show you this passage, but His Lordship's paragraph 30 at page 592, where he says contractual arrangements for discontinuous work may at least in theory fall into three categories. And so those are his three categories. At some stage, my lord, it is worth seeing what he says from paragraph 22 onwards. He has a heading, mutuality of obligation. He cites from Cable and Wireless, that's not in the bundle, but paragraph 25, page 591, he rightly identifies the obligation on the employer being to provide work. And then he recognises that that's qualified in Cotswolds at letter H as the obligation to provide some work. But it's his paragraph 27 at the foot of page 591, and in particular the top of page 592, he cites from Clark and Oxfordshire Health Authority that the requisite mutuality of obligation must subsist over the entire duration of the relevant period. And the relevant period is the period of the existence of the contract alleged to amount to a contract of employment.
And this is your Monday to Saturday lunchtime point.
Yes. So,
It may be that the respondents don't disagree with it, provided that the mutuality obligation is defined in the way that it is at page 284, letter C. That is that there is an agreement, a persisting agreement throughout the whole of that period.
If mutuality is put in terms of the existence of the agreement, well, that would follow. Yes. So that's my second point. My third point is the fact that payment is made when work is done is not alone enough, even in a specific engagement, instead, what one has to find is a continuing, enduring obligation to provide some work and a continuing, enduring obligation to do some work throughout the whole of the period of the contract. And it's that proposition that explains the result in three cases: McMeechan, Prater, and Weight Watchers. And just if you have Weight Watchers still to hand to save me coming back to it, my argument in Weight Watchers is encapsulated at page 601 under the heading Mutuality of Obligation, paragraph 83. And in particular at paragraph 87, page 602, and what's described as the sheet anchor of my submission, letter D, condition 10, which entitled the leader simply not to turn up and take one or more meetings. And it's that submission that His Lordship rejects at paragraphs 88 through to 93. Because having identified that you need mutuality of obligation throughout the contract, he finds on the contract in place in that case that there was sufficient mutuality throughout the whole period. Now, there are two earlier cases that my learned friend relied upon before the Court of Appeal, now addressed here by the Court of Appeal. The first is a case called McMeechan. And that begins at page 409. Mr. McMeechan worked for an employment agency under a series of temporary contracts where his services in effect were hired out to end clients, and he had provided labour services, and then the agency who engaged him went insolvent. And so he made a claim against the Secretary of State for Employment, contending that he was an employee of the agency. Now, the Industrial Tribunal said he wasn't an employee. The EAT decided that he was an employee, and the Court of Appeal agreed, but for different reasons. Now, the way the argument was put in the Industrial Tribunal and in the EAT was that he was an employee under an umbrella contract. And just so you can see the import of this, this is Lord Justice Waite at page 412, letter H, foot of that page. He identifies the conditions of service for temporary self-employed workers, and then they run to the top of page 413. And can I invite you to note conditions 3, 5, 6, and 9. So 3, the contractor agrees to offer you the opportunity to work where there is a suitable assignment with a client. The contractor reserves the right to offer each assignment to such temporary worker as it may elect. And then 5, letter C, you are under no obligation to accept any offer made under paragraph 3, but if you do so, you are required to fulfill the normal common law duties which an employee would owe to an employer. And they're set out. And then 6, at letter G, the contractor is not obliged to provide and you are not required to serve any particular number of hours. In the event of your declining to accept any offer of work or failing to attend work for any reason for any period, this contract shall terminate. And then 9, at the foot of the page, you acknowledge and confirm that the nature of temporary work is such that there may be periods between assignments when no work is available. Now, what Lord Justice Waite records at page 421 of the bundle, foot of that page, there's a heading, the argument in the Court of Appeal. Mr. McMeechan represented himself. Lord Meston was acting for the Secretary of State. And then he records Lord Meston's submissions, but relevantly picking it up over the page at page 422 of the bundle between letters D and E. As the argument proceeded, it appeared to the members of this court that the relief for which the applicant was really and primarily asking was to be treated as an employee of the contractor in respect of the stint he served with their client, Sutcliffe Catering. And just pausing there, the contractor is the agency. So they had addressed an umbrella contract argument, and they were then saying, well, the real argument appears to be that he was engaged under a specific contract for 4 days. And Lord Meston's argument was threefold. So between letters E and F, he strenuously resisted on the merits, however, on the following grounds. 1, specific engagement cannot, as a matter of law, be severed in the way that it is proposed from the general engagement. And then 6 lines down, letter G, 2, even if 1 is not a proposition applicable to all cases, it must apply to a case like the present, where the conditions govern both the general and the specific engagement. And then at letter H, 3, if contrary to 1 and 2, the individual stint is capable of giving rise to an independent contract of employment between the temporary worker and the contractor, the absence of mutual obligation to provide work or to do it is still relevant, and fatally so for the purposes of construing the terms applicable to it. So Lord Meston's case was, you can't have a contract of employment that's a single engagement, or if you can, you can't separate it from the umbrella contract, or if neither of those are right, there isn't the right sort of mutuality. And those 3 are addressed in turn by Lord Justice Waite, beginning at page 423. So the heading, letter E, the single engagement claim, A, is it maintainable at all? He doesn't label this, but he's here addressing Lord Meston's first and second reasons. And he rejects those arguments on the basis that a single engagement could be a contract of employment, and there is no necessary barrier to working out the terms of that specific engagement by looking to the terms of the engagement and the umbrella contract. He He then tackles Lord Meston's third point on page 424, letter H, B, the merits of the single engagement claim, and he records that this was a claim for 4 days' work that was done by Mr. McMeechan. And the question is, did or did not amount to a contract of service in its own right? That is a question which, though it remains essentially one of fact and degree, is one which largely falls to be determined on the interpretation of the conditions. And then what he goes on to do in that next long passage between letters B and G is to conclude that once one understood the nature of the conditions that were imposed on Mr. McMeechan during that 4-day period, that 4-day contract was a contract of employment. Now, relevantly for my purposes, the significance of McMeechan is it's an example of a single engagement contract for 4 days that was held to be a contract of employment because the conditions that were imposed on Mr. McMeechan throughout all of those 4 days were on analysis sufficient to make it a contract of employment. But what the court does not say is the simple fact that Mr. McMeechan should have been paid. I say should have been because his complaint was that he wasn't, but the simple fact that he should have been paid is itself enough. The other case relied on by the Court of Appeal below is a case called Prater, which begins at 525 of the bundle. Decision of the Court of Appeal involving a claim by Mrs. Prater, who wanted to establish a period of continuous employment where she had been engaged as a home tutor to teach pupils who could not be taught within the school system, where each particular engagement was to teach a particular pupil. So there was no umbrella contract, there was just a series of individual contracts. And the individual contract was to teach a particular pupil for as long as that pupil needed teaching. So in one of the examples, she taught for 5 years because the particular pupil required teaching for 5 years. And we get the nature of the obligations owed by the parties from paragraphs 8 through to 11 of Lord Justice Mummery's judgment, page 528 of the bundle. So paragraph 8 records the council was not under a contractual obligation to offer pupils to her. She was under no contractual obligation to accept pupils. But then paragraph 9, having agreed to take on a pupil, Mrs. Prater regarded herself as having undertaken a commitment to the pupil to deliver teaching on a regular basis. Teaching would continue for as long as was necessary. 10, she taught a number of different pupils each week, some for 5 hours a week, some for as much as 10 hours a week. The duration of the individual engagements varied from a few months to several years, one lasting for as long as 5 years. And then paragraph 11, although Mrs. Prater was not obliged to accept pupils offered by the council, once she had agreed to take on the work, she was obliged to fulfil her commitment to the particular pupil, and the council was obliged to continue to provide that work until the particular engagement ceased. So the debate was that engagement a contract of employment? The Employment Tribunal said yes. That's paragraph 21 in His Lordship's judgment, page 529. The EAT agreed, paragraphs 23 and 24 at page 530. And then the council's submissions on appeal to the Court of Appeal are recorded in paragraphs 26 through to 30. What the council said was there needed to be a continuing obligation to provide other work to Mrs. Prater in order for the specific engagement to be a contract of employment. And that was put by Mr. Heppenstall for the council at paragraphs 26 through to 30, in particular at 30. What Mr. Heppenstall said, well, that's the obligation required by law, and it's just not present. And that's rejected by the court. Lord Justice Mummery at paragraphs 33 and then 34 through to 40, on the basis that for Mrs. Prater there was an obligation on the part of the employer, Cornwall County Council, to continue providing the work for the teaching of a given pupil, and she had a continuing obligation to teach that pupil for as long as it was necessary. So if one addresses it in the terms of Mr. Justice Briggs in Weight Watchers, it was a case where there was an obligation that subsisted throughout the contract to continue to provide the work and to continue to do the work.
So the council couldn't have said to her, we're now switching to a different teacher.
As regards pupil
particular
A.
pupil.
Yes. And that's encapsulated in Lord Justice Longmore at paragraph 40 on page 533. In particular, letters D and E, the important point is that once a contract was entered into, and while that contract continued, she was under an obligation to teach the pupil, and the council was under an obligation to pay her for teaching the pupil, made available to her by the council under that contract.
That's still
I'm sorry, that's
Justice Mummery, I
it
think.
is just it is. My apologies.
Give me the reference again.
It's paragraph 40, Lord Justice Mummery, page 533.
Thank you.
And it's Lord Justice Longmore at paragraphs 42 and 43 on pages 533 and 534. So in Meacham, there was a contract for 4 days, and the obligations subsisted throughout the 4-day period. In Prater, there was a contract that, in one instance, was 5 years long, and the obligations subsisted throughout the term of that contract. In Weight Watchers, despite my best efforts in the upper tribunal, it was found that there was a contract that could be a year long, where the obligations to do some work subsisted throughout the whole period. But in the present appeal, there is no equivalent obligation, since PGMOL can, after offer an acceptance through MOAS, change its mind, and the referee can likewise, after offer and acceptance, decide not to do the match.
And how would they find a referee then for that match? Will they offer it on MOAS again?
Yes, and the evidence was that there was a pool of referees who could be called upon. And so if there was a last-minute decision either not to offer or not to do, they would find a replacement.
Well, does that not amount to saying either that there's a right on either side to terminate the contract at will until Saturday. They were all saying that there isn't a contract until then.
My Lord, that is my next point. I wonder, looking at the time, whether that might be a convenient moment. But, my Lord, I will come to that exactly at 2 o'clock.
Certainly, Mr. Peacock. The court will adjourn.